what it was.
Well, I talked to her a little bit out.
Yeah,
So I
yeah,
stay
because she was at the party.
You're
Yeah.
That was Saturday. Well, she was such an integral part of the I think that's.
Yeah.
So how was Red Ann's Pants?
It was good. It was really good. It was
Did
crowded.
you go Sunday or what?
No, just Saturday.
Saturday.
Yeah.
What would you say the crowd was? How many over there? 5,000, 10,000?
I hear they get 10,000 for the weekend. Saturdays are less than Sundays. As far as a guess, I would say maybe they had a third of that on Sunday.
The crowd was down on for Myrtle Heights.
No, Merle was on Sunday.
Yeah. Oh.
Yeah. And a lot of those will stay the whole weekend.
Yeah.
The camping area is bigger than it's ever been. So I shouldn't even venture a guess, because I don't have a clue.
How many were there?
One of the guys that was at the Merle Haggard concert last night said that he thought there were 4,000 or 5,000 people there.
Yeah. I would go with his guess over mine.
For you.
Still a lot of people.
Yeah.
By the way, the thing that we have to decrease a easement on a lot, we've got enough proxy votes to carry it. So, whatever we can do to get it on the agenda and get it speeded up, I'm sure that
I think you're on for next weekend, right? Or next Monday?
right. I didn't know if the county would have another time period before they could decide.
Only if there's opposition.
Okay.
Yeah.
So far, there's been no opposition at all.
Excellent. That makes it easier and streamlined.
Yeah, yeah, he'll be happy to hear that.
Yes.
Is he gonna be here this week?
And Tim has canceled as well at 10:15. Yeah.
Okay.
Not late, 11:30 is when his appointment, Sean Higley and maybe Mike Conkey right after that.
Oh, he's down over on the fires again?
Oh, he's hoping to be back today.
Yeah.
They
I've
got
been
it
there
out.
on some of those.
Yeah.
He's probably got his time in and he has to take a rest.
Oh, yeah,
Right.
you know, it's what,
Gotta be exhausted.
14 days or 17 or something like that.
Yeah.
I forget what it is.
I forget.
We've hit those.
We have some extra chairs that you guys can take from the table here,
Okay.
so that there's enough for you to sit.
Sit in the fire hall.
Or who made this take their hand? Was it Jim Bagley or Bob Bagley made that, or who? Okay. But was it made locally? I mean,
Yeah, it was.
by somebody here. Wow.
Yeah, Armstrong.
Oh, Monty.
Yeah.
Oh, Monday,
Oh,
okay.
Sure.
Looks like Monty's work.
Yeah.
Mhm, yeah.
And this front part can come off, right?
Are
Is
you
that,
Mark?
or is it hooked on?
I honestly don't know.
Yeah. I think it's hooked on.
It's nice to meet you.
Yeah, but I think it can't come
You
off.
too.
Yeah.
Yeah, it doesn't have any legs.
It's
It's
not
not
church,
tight.
I just think. Yeah.
You see how they work the last people in, get the most comfy chairs? Well done.
He planned
Thinking
that.
that.
He planned that that way.
So Tim canceled?
Tim Ravendall has canceled.
Oh,
That's what
okay.
you were asking.
Just canceled.
Keeps pushing it, pushing it. Doesn't want it. You know, it's good there.
Yeah, that's what she said.
This one.
Oh, no,
He's
don't
been
scare
there. Yeah.
Oh,
No.
horrors.
Half your crowd will leave.
Right,
Kind of everything.
yeah.
Well, no, I don't want to. You don't? No, I do. Take it.
I'll print some more for you.
Okay, so give her.
Everybody called you and
Have you used
some
the
deep
ones?
discussion there, I almost forgot him.
But you can add for spots on those.
So we almost got all the problems of the world solved.
You want
Yeah.
my second?
Oh, no, I barbecue.
Oh, we solved everything down
Yeah,
there.
yeah. Is this your
Laura?
writing?
How much do those pins cost?
No, that's Carla May Bosses.
Any idea?
They're not that expensive, they're surprisingly less expensive.
Like $100 or?
Round about that, yeah. I don't remember what the cost is, BCDC got one as well. Ernie's the one
There's
that
4 different
told Board of Health
proposals and
about this
stuff
one,
like
which is the
that.
one I'm
Oh,
on.
really?
So I don't know, but I'll find out.
Oh, that's all right, I just was
They
looking
aren't all
for
the
a
same.
kind of
No,
a.
they're all different.
Didn't you say Andy thought a couple hundred?
Yeah, I think by the time you get, if you want the soft.
Well, I would like to, because the audience is so adamantly gun rights, you know.
Special note,
That I
I'm
have
sure
to
those
have
are additional.
Right.
Information.
Morning.
Talk to her about.
I'll just, maybe I'll have to write mine out.
Might be a good idea. I think comes at it from a different angle, but.
Are there no more chairs?
No, there's
There's
one in the
one,
corner.
like,
There's
way over
one
here.
there.
You
Oh, the head leaner.
I did. I did. I'm experimenting.
Should have
That's beyond my pay grade.
Oh, I see.
Yeah, they don't let me make holes in the building.
Maybe
In that direction, not this direction. Please.
I'll take it under consideration. Yeah.
I didn't see you there eating lots of corn dogs.
Oh, I wasn't there. I went to rodeo this weekend.
Well, you should have been down there at corn dogs.
I should have.
You know, I mean,
They're not good. I'm trying to maintain my figure.
you had anywhere from the, 7 o'clock until the power went out, you know.
That's true. That's true. Power went out at the house, or was out when I got back. So I had to reset everything and freak the dogs out.
They cut me out at 7 o'clock.
Is that right?
And then it came, and then they were, but it wasn't out at my house. And then it went out at my house about 2 for about 5 minutes or so, I guess.
Oh, good. Well, we hope that at least we live at the silos.
Yeah, I hear you.
Burned the power pole, I guess.
I was wondering if somebody ran into it.
That was the short
Didn't get things down very far because the property
had been told
right behind us got sold and they started drilling a well this morning. And they weren't at it very long before we saw dust fly on it. They weren't down very far.
So I guess they had to replace the pole and the transformer. Mike had called since 1 o'clock they were gonna do it.
Just saw your head poking in, we have another chair right here if you wanna snaggle that one. Hey, John, can I have you move your chair up here, just because I think you're blocking the doorway there.
I can get through there.
If you would move your chair up here, that'd be great.
Where do you
Right up
want?
here in front of the door.
Okay.
I was worried about this fire lane.
All right, thank you, excuse me, thank you for joining us today. Go ahead and call this meeting to order, and if you'd stand with us and bring us the Pledge of Allegiance. I pledge
allegiance to the flag of the United States of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all.
All right, thank you for joining us today. This is the Broadwater County Commissioners meeting. It is July 29th. And just a couple of reminders, housekeeping. We are now on YouTube, as well as having these meetings recorded. So if you have a comment to make, if you would please be recognized by the chair and state your full name for the record. Also, Elaine will not be joining us today. So we will go ahead and get started. First thing on the agenda, has been on the agenda for a while, is Greg and Heather Norsby. And we do not have a quitclaim deed for you on the property. We do have an email from the county attorney. She's not here right now, and she asked that we read that for you. There's also some other citizens with the same concerns. And I understand you have a copy as well?
Yeah.
Okay, excellent. And I will give you this for the record. All right, it is dated July 22nd. Commissioners, I have reviewed, and she asked that we read this. Commissioners, I have reviewed the materials forwarded to me April 12 and set forth my opinion for commission action below. First, however, I feel compelled to address the numerous complaints from the Norsbys with regard to the delay in getting this issue addressed in my office, and would ask that you share my response with the Norsbys in the next meeting, which I will be unable to attend in person due to long-planned break from the office. I have set forth in writing once already to the Commission a lengthy explanation of the statutory obligations of this office. By way of a quick reminder, this office's first obligation per MCA is to criminal, youth, dependency, neglect, and mental health commitment actions. The deadlines and requirements of those cases will always take priority over any civil business of the county and the city of Townsend, which this office also represents by interlocal agreement. Next in line is the statutory requirement that this office provide legal advice and representation to various county and city by interlocal agreement departments. This advice and representation must be prioritized according to importance based on issues with time sensitiveness, court deadlines, filing deadlines, etc., taking priority over matters that have no specific time sensitivity. With regard to the particular matter at issue, while I recognize that to the Norsbys this matter is of utmost importance and they seek to have it resolved immediately, this is the same sentiment held by every party to any kind of legal action. To my office, it is only one of many matters competing for time and attention. It is also a property issue that is some 58 years in the making and which has no specific court or filing deadline attached. While I regret that it has taken my office as long as it has to fully address this issue, I will not apologize for it because my office has diligently followed MCA in prioritizing our workload, and given the special circumstances of the last 100 days since this issue was brought to my office's attention, I assert we have addressed it as quickly as we possibly could. The below is a list of some of the special circumstances faced by this office in recent months. We were without clerical staff for a few days, shy of 2 months. Immediately following the receipt of the Norsby Hill Street request, this lack of clerical assistance required me to take a great deal of time away from lawyering to devote instead to various other tasks also required by law, such as the dissemination of evidence in ongoing criminal cases, and we have filed numerous serious felony cases since April 12 in addition to our ongoing caseload. We had to engage in the hiring and then training process to replace the clerical staff person who resigned. The county has come under investigation of DCI FBI on a serious code of ethics allegation, and numerous related citizen complaints were filed in my office which required immediate review. One commissioner filed a lawsuit against the other 2 commissioners, a situation of potential liability to the county which required an immediate response from this office. An ongoing personnel investigation has required the time-sensitive response of this office on many occasions during that same time period. Various county departments, including this office, have been faced with numerous public records demands from individual citizens which have resulted in further demands of this office's time to conduct review for confidential content and to assist in providing response. We have continued to engage in handling the regulatory, busy, criminal, and civil workload of the office in light of all the above special conditions. My advice specifically regarding the closure of Hill Street in Toston. It is the advice of this office, confirmed after consultation with General Counsel at MACO, Montana Association of Counties, that the Commission should not proceed in passing a resolution closing Hill Street in Toston based on the process of public notice, hearing, and opportunity for comment, which we can only presume took place lawfully some 58 years ago, in accordance with the statutory process, which has since been altered in at least some respects by the Montana legislature. Rather, the process of road abandonment closure via petition, public notice, hearing, and opportunity for public comment should take place according to current statutory requirements set forth in 714-2601 MCA. After which lawful process, the Commission should take immediate action on a recommendation for closure, should said recommendation be forthcoming from that process. With regard to the associated request by the Norsbys for quitclaim deeds from the county does not actually own the property comprising Hill Street, but rather has a statutory interest in the property for the purpose of using it for a public roadway. Once a road is abandoned or closed pursuant to the lawful process prescribed in MCA, the county's interest in that property automatically reverts to the adjoining property owners after the county's easement has been forfeited by closure of the road. The county should not be issuing quitclaim deeds because the county has no actual ownership interest in real property that can be lawfully transferred to another by means of a deed. I have spoken at some length with Bernadette Swenson at DMS Surveying. She is copied on this email, and it's my understanding that there may be a property dispute between the Norsbys and adjacent property owner William Lane with regard to a deed held by Mr. Lane, which appears to transfer to him an interest in property adjacent to the Norsbys, and upon which a structure belonging to the Norsbys may encroach. That deed transfer takes place between another individual property owner and Mr. Lane. There is no involvement of the county. The county takes no opinion as to the accuracy or legitimacy of that deed transfer. Any possible dispute over that deed transfer in the property and or encroachment in question is between the Norsbys and Mr. Lane and requires them to seek private legal counsel to resolve the issue if they cannot resolve it between themselves. As a reminder, the county attorney is expressly prohibited by MCA from representing any individual citizen in any private legal action. So it's again my advice that at the next meeting, the commission advised the Norsbys to proceed with a petition to close Hill Street in Toston pursuant to the process prescribed in 714-2601 MCA if they desire to see that road officially closed. Because it appears that the lawful closure of Hill Street is unlikely to solve the problem at the root of the initial request, they may not be so inclined. However, it would be my recommendation that this process still take place at some point in the near future to finally resolve the status of Hill Street Toston, which to this day, regardless of usage, remains officially a county road for the benefit of all the adjoining Toston landowners. Please advise if you have questions or concerns. Thanks, Carla May Bossy, Broadwater County Attorney. I will hand that to you. And if you do want to go ahead and proceed with that, Nicole, the county planner has a petition, or you just need to give
I
signatures.
just have a few more questions for you, I guess, as commissioners. If Hill Street is open, where would it be open to? Because Hill Street runs in front of my garage and somebody has built a fence there. So if it's an actual open street, why is there a fence at the end of it? I understand bridge is closed, but if it was closed and the land reverted to the adjoining landowner, that would be my lot. And I don't believe, I'm not sure, but Bernadette was here and has the deeds, and I don't see how somebody could have a deed on a county road then, if what she's saying is the fact. So I guess as commissioners, if it's an open street, then that's kind of your issue. Why is it closed in front of my garage door? So I'm fine leaving the street open. The initial when we came here was whether the street was open or closed, and we knew the process of petitioning and getting adjoining landowners to agree and the whole bit. I understood that process, and we were looking to do that process, and it went to the attorney for The clarification, which I guess she has clarified it at this point, to the point that the street's open, but nobody's clarified why there's fence in front of my garage door then. So, I guess we're still at the 100 days ago. You know, we're at the same question right now as we were 100 days ago. I'm not sure Bernadette had some paperwork and stuff, right?
Well, I had given them the deed that Bill Lane had.
There's a deed on the end of Hill Street then, the intersections of Hill and Bridge Street. You guys have an active deed that she had given you?
Well, and all I can do is, or all we can do is refer to Carla's, legal comments in her letter. But the county does not verify, maybe I
Well,
should
it's an
read the
open street,
language.
so where do I go? Do I go to the police to remove the fence, or who do I go to? It's an open street, you're telling me Hill Street is open. My garage fronts on Hill Street and it's got a fence in it, so I just don't, you know. Hiring a lawyer and taking this to a private, it's your guys' issue really in an open county street. I mean, that's your guys' issue. I can't just go out in the middle of, let's see, Ferry Street on the other side of my place is an open street and throw a fence up. I mean, somebody's gonna get mad. So, and that would become your issue at some point. I mean, at some point, somebody in the county has to have some more say in this, I would think. I mean, I just can't see how there could ever been a deed that came about on a street that's not closed, so, or the intersecting points of it, or any of that, so. I don't know, do you have the deeds with
Well,
you now?
I do,
Or
but-
the deed on the end of Hill Street and intersecting points of Bridge and Hill?
Yeah, I'll just.
Oh, absolutely, please do.
I think the question is, this was a very rough draft, I had just a couple minutes. Hill Street and Bridge Street intersection. Bridge Street, when it closed right to here, you know, to the Hill Street is assumed to end right here. So, by law, the abutting property, the vacated street adjoins, or is absorbed to it. So, this would be Norsby's lot, they would have acquired this half of Bridge Street. The abutting property here, you know, that's where it gets into a confusing error, because Hill Street cannot extend into Bridge Street, so it's assumed it ends here. So this portion right here, which is what is in question, abutting can't be diagonal, but if Hill Street and Bridge had been at the same time, then it probably would have been a intersection point here. So that's where, you know, a lot of this discrepancy
Not really
has.
diagonal, if this became mine when this all closed, it's all, I mean,
Right, that would
can't
be-
diagonal, that just, it doesn't.
It's the way the law, abutting, this would be abutting, this then becomes abutting after this, but it's like a second step. And I see your point 100%, and, but I'm just saying that is the reason why this probably happened at that point in time. And I'm not saying it's right or wrong, or you're wrong, but, you know, that's where.
Where's the deed? Who would write the deed on this property then? Who gave this piece of Bridge Street to anybody?
I
That's the county's
have-
property, that's part of, it's all West County property, this piece, or whatever it was, roadway, and then, it's just,
And
so
all
let's
I
say
have
the
is-
commissioners came out in 55, looked at this, seen buildings at the end and said, oh yeah, just close Bridge Street or whatever and do this thing, I mean, it just doesn't make any sense, that there's garage doors right here, a garage runs right down the street line, and that anybody's gonna give that away to anybody else. It makes no sense. And it makes no sense that, because somebody owns all this land over here, that they can jog in like this at an intersecting road and back in and out. That makes zero sense also. These pieces would go with these properties with this street, or that would stay as part of that street. I mean, it just, I understand
Yeah.
what you're trying to say, but it doesn't.
Well, and I
mean, it doesn't
can't,
make
I
no common
wasn't
sense
even
that we
alive in
don't govern
55,
that
so.
way. Right, but we don't, I wasn't either, but I'm sure they had a lot more common sense than we got right now, and they wouldn't have something happen like that.
Yeah.
I mean, it just wouldn't happen. So-
Well, and like I said, I have the deed from Greaves to Bill Lane. I have nothing further behind that. I mean, you know, the history or when did they get it, or if it was, I don't have that. Bill Lane had asked me to make sure it was on his deed, and you guys had, so I pulled his deed and it was, so that's as far as I went.
Yeah, from 80 or 88 or something,
Mhm.
surveyed by your guys' office.
Not in
Surveyed
88.
out right here?
No, not in
You
88.
didn't,
That
did you
was,
guys didn't
we,
do the original survey on that?
we did the survey in, it was around 2000s or whatever.
Was that when
we
Bill bought it, or he
retraced-
resurveyed it?
We, Don Schauber surveyed it when Greaves owned it.
Okay. So Schauber surveyed it in 88 or something when Greaves?
No, we weren't even here in 88. We surveyed later, and that's why there were existing deeds from the 80s and the 50s on like this piece here that adjoins Doug Brecker's and
It's a
stuff.
written, I've read that, it
Yeah.
starts at Breckers and goes that way, and 2 meetings ago, we stood right here and said that nothing comes this way, that there is nothing that comes this way on the maps. I remember plain as day standing right in front of this table, and there was nothing from Brecker's piece towards me that was in effect. And I know it's on that map because I seen it circled out there, but again, like 4 meetings ago, when we talked that it was Xed out there. I mean, it just,
No, we
that
said
a survey map is.
there were no deeds down here, except all the way down here was another piece that Greaves owned. Below lot 6 of block 2, or 1, whatever this block is. But there were no deeds, we said, on, these
From this
pieces.
piece down. Or
No,
Brecker's
from
down.
yours and, well, I have the copy here. Too many paperwork. Here. See, there were no existing deeds coming down here.
Where would the, I don't see how it would be deeded if it was county property.
Well, that's something that,
It
you know,
went
could be
to the-
researched.
But it went to the adjoining property
Yeah.
owners, and I just don't see.
Right, and like I
And
said,
again,
I'm
I guess
not,
if Hill Street's open, it sure seems to me like the end of it's not.
One
Because I
thing,
joined Hill Street.
question for you, Bernadette, is if Hill Street were closed, then those 2 pieces that are diagonal would no longer be diagonal. They would be adjacent to a property owner's property, so those would go with the property, correct?
if Hill Street was closed,
Mhm.
yeah, it probably
Because then it's
would've.
adjacent, not diagonal.
Right.
Okay, so it seems to me from Carla's letter that that's the simplest solution is to just put together you don't need that many signatures. We can go through the process, get it closed officially, and then you've got that corner piece right now, which will be adjacent then, and then the other half of Hill Street through that process.
Yeah, except if Bill Lane is saying that he's got a deed on that piece of property right there. The statute reads that you need, I think it's 75% of the adjoining landowners. We can only there's 3 adjoining landowners to that property. There's me, Doug and Drifty, and Bill. So there's 3 landowners. If Bill's got, it only gives you 66%, so it doesn't meet the criteria to close the street then. If all Bill has to do is say, no, I don't want it closed, he adjoins it right there at the end. So, it leaves you in the same boat that we're talking about right now. It really does, because if he's got a unlawfully given deed to the property. If it was just missurveyed is all that would have had to happen, just a missurvey that somebody assumed that it ran past here. The quitclaim deed I read starts at whatever, this is lot 1 or something, and it goes the other way. That's the deed I read, or the quitclaim deed that we pulled out from the past. I've never seen anything written on this piece right here that we pulled up. I mean, I just haven't. Whether it was described in a survey is possible, that was done, I don't know. I mean, I don't know, but if it was missurveyed, it was missurveyed. I mean, it's, again, we've talked about that, and a survey is nothing but a pretty map. If they didn't own the land to give away, they can't give it away. I mean, I could say, yeah, you're gonna come out and take my piece of Hill Street, I'll just take it, I don't want it, you know, what the heck, give it to Doug and Drifty or whoever. Well, if I don't own it, it's not mine to give away. So I just don't see how that can be given away, and then it doesn't make any sense to me, I guess, and that's why, again, we're here. And it's, I guess, without any, I don't know, I mean, I just don't know. I don't think it becomes a private issue. I think the county's as involved as anybody if it's the streets. I mean, I just do. I'm, honestly, I think there's a question on the way, and I don't know for sure, but the way closure of streets, and you're saying the county doesn't own them, I understand you might not write deeds on them to give them back, but that's stating that there's nobody taxed on that property. So if I just take ownership of, if you close Hill Street, and take ownership of half of Hill Street, I'm never gonna be taxed on that? That doesn't become on the tax rolls then at that point? Bill's obviously paying taxes on this because it's part of his legal description. Except, what about the other half of Bridge Street? It doesn't fall under my tax description. There's just all over the place. I mean, it's all, everything is so, seems willy-nilly put together that, because she's saying that it's not county owned, and in municipalities, I thought the streets were owned by the municipality or the incorporated village or whatever it is, and I think your husband was even the one that kind of explained that to me. So he was even under that understanding also. And I don't know when the law changed that the county doesn't have it, but it's surprising to find an untaxed piece of ground in this nation, I can tell you that. That's really surprising for me to believe that I'm gonna own a half a street and be untaxed on it, and I can put buildings up on it, do what I want with it. You know, it's just, that's unheard of, really. So,
You don't pay taxes, you get a deed for it.
right, and you wouldn't get a deed.
Right.
Because you never deeded to me.
I think county responsibility to find the entire layout of Hill Street, south from Ferry Street.
Right, where Hillwood runs to.
Right.
And why would it
And being it's
close?
open,
Right.
the pins will be wherever the end of Hill Street is, since it isn't closed.
Right, do streets intersect in the center point, or do they intersect at the edge of them? That would be the matter at hand, really, is what it is where is the closure point of a street? Is it, if you got an intersecting street, does it, you know, if you close one, does it close the end of that street, or does Hill stop here? If Bridge wasn't closed, it would, and you closed Hill Street, it would stop here. But if Bridge is closing and Hill Street's open, what makes it stop there? And especially when you got a garage door coming out at the end of it. I mean, it just, none of it adds up. None of it adds up. So, that's kind of what the clarification I'm looking for. If it's an open street, where's it open to? Because it's not just a fence that somebody put up or a survey pin, because just like you told me in the past, was a survey map, and pins are nothing but a pretty map if it doesn't have something to back it up. And I'm here saying I don't think there's anything backing it up. I really don't. This piece has had buildings on it for years and years, so it's been obviously owned by this piece, and that's my piece. So that makes this street should be open, or I'm an adjoining landowner to that. I mean, one way or the other, I'm adjoining that, and it's it's a chicken and an egg thing. I mean, yeah, it closed, but it closed at the same time this closed, so that makes me adjoining. I mean, it's not, you're not gonna jog in and out of every intersection because somebody's got a bigger piece of land. I mean, that's crazy to think that that's the way it works, to jog in and out at every intersection where you butt a road and give that land to them.
As much as what you've said, Greg, makes an awful lot of sense, and I think every one of us in the room can agree that oftentimes Montana law does not make common sense. This is not something that we can override as a commission. This is from the county attorney and her interpretation of Montana state law. At this point, I certainly understand what you're saying. I think the commission understands what you're saying, but there's nothing that we can do. What I would suggest is make an appointment with Carla when she gets back. Perhaps ask for a conference call with the Mako land use attorneys and see if you can get some clarification on your answers to your questions, one, and also what should be your next steps to, solve the issue at hand. As far as this commission overriding the county attorney, it just,
I'm not asking you to override her, I wanna know where the street's closed.
That's what I said, that's why we gotta have a survey there,
I wanna
find
know,
out.
I'm living in the county, in the town out there, and I wanna know, this street, you just told me is open, Hill Street is, so I wanna know where it's open to. Where is it open to? Just, that's what I'm asking at this point. I mean, we came here understanding early on, the initial meeting was that Hill Street wasn't closed, we already agreed upon that, and we were going this process to get it closed. At this point, if it's open, let's just make sure where it's open to.
we
Is it
didn't really
illegal?
start the process to close it.
No, but that's what we were here for, we came here
Initially,
with that.
yes.
I knew the statutes and I knew the process of closing, and I understood all that. And that's, the initial was to talk with you guys about that portion. And it was recommended that we send the wording of back in 55 or 58 up to Carla and have her review it to see if it was the case. And I understand that, but if I go to her and ask her where the street's closed to, she's not gonna know. She's never set foot out there, she doesn't have any clue as to where the street's closed to or open to.
Another,
I mean,
another
it's,
person you can talk to, Greg, would be the county land use planner. And again, she could also have a conference call, or on your behalf, place a call to the Mako land use attorneys, and they should be able to answer some of those questions for you as well. Not the legal questions, but maybe the street closure questions, and also come up with perhaps a suggestion on the best way for you to move forward.
At this point, there has to be a survey where the end of Hill Street is, so until that's done, the rest of these questions are already answered. I say it's gotta be surveyed out. The intersecting points on Hill Street, south of Perry Street.
Is Nicole in here? Hello, Nicole. Do you have any insight you can add to these questions?
I guess I would like to be able to visit with Greg in my office and maybe we can go through your list
You
of
betcha.
questions and kind of see what we can come up with, because I'm hearing that you might want the street closed.
I'll go either way
But
with
then
it.
I'm also hearing that you want that fence out of the street, and so I think that maybe we
We can
should.
either close
kind
it
of
or open
see
it
where
or
you
do
wanna
whatever
go
we
with
wanna
this.
do, but if it's open, then it needs to be open, but yeah.
Right.
That's fine, you do it now or you're busy now.
No, I'm thinking that if you wanna step into my office, we can work this out outside of the commission, because I think Carla has given the commission her opinion. And then I can come back and just kind of update the commission as to where we're going maybe in a week or so, after you and I are able to visit on this.
Very good, very good.
Thank you very much.
And I would like to
Thank you.
clarify too, to close a road in the county takes only a majority, not 75%.
Okay,
So-
that's not what the statute.
No,
means.
it is, I have the
Okay.
statute,
Well, it's got
so-
different
which is
amendments.
good for you. Thank you.
Thank you very much. All right, we have the Commissioners' Community Update. We go ahead and postpone that till later. Tim Ramadow with Preservation Act and the Second Amendment, he canceled earlier this morning. And so at 10:30, we have Julie Lethert, Sanitarian, revised resolution for notification of purchases, MCA code 76-4-113. And it is 10:32. Do we have Julie Lethert here? All right. We can still proceed with this. Julie Lethert is the county sanitarian, and she brought this forward to the Board of Health. We actually visited this subject about a year ago, and we talked talked with a couple of realtors and a gentleman with a surveying company. So hang on one second, I'll just get the paperwork out here. And Ann, yes, I did, thank you. Ann with the clerk and recorder's office also sent copies of this resolution to title companies, real estate companies, and other clerks and recorders. Ann, would you to start, share some of the comments that you received from the different people that you queried on this?
Okay, this is from Bonnie Ramey, who is clerk and recorder, assessor, election administrator from Jefferson County. A representative from DEQ approached the association members several years ago. DEQ had concerns over future landowners not being aware of agreements, easements between landowners for placement of water and or drain fields, as well as the certificates of subdivision plat approvals that have been put of record in this office. They were asking us if there was a way for us to ensure that all future purchasers of land be made aware of these recorded documents. The members who were present during this meeting let him know that there is no way we can place these documents. We are not title examiners and we do not want to assume this type of responsibility. 764113 MCA applies to subdivisions, and she goes on and explains that. However, a large portion of our land transfers are not subdivisions, and 764113 does not apply to these transfers. Therefore, I would not refuse to record a deed that does not have reference to the documents that lift sanitary restrictions. I have this from Ray Stroman, who's Senior Escrow Officer at Rocky Mountain Title and Insured Closing Services. Our concern is the delayed recording of a deed this will cause. Deeds coming out of long-term escrow will be unable to record. Also, what will happen when a foreclosing attorney mails a trustee's deed to the clerk and recorder? Will they just send it back? This proposed regulation is going to make the recording process too cumbersome. How is it that the other 55 counties in the state don't seem to be having this problem? We as a title company strongly oppose this regulation. This is from Doug Tetters at Surety Title in Helena. In regards to the proposed resolution to establish a revised Broadwater County notification to purchasers, I strongly oppose this proposed resolution for many reasons. To begin, as a land title insurer and closing escrow agent, I feel if this resolution were to pass, this could cause significant delays to the closing for real property owners in Broadwater County and possibly cause a devalue to the properties in Broadwater County due to their individual septic sanitary situations. Also, how should the clerk and recorder's office handle certain situations such as old deeds coming out of long-term escrows, deeds filed by out-of-state individual companies that do not know of this resolution, and foreclosure deeds filed by non-Montana businesses for property in Broadwater County? Can you imagine all the postage and mailing that would be needed to mail back and through the clerk and recorder's office would have to handle that burden? Also, the title reports title commitments that land insurers issue to buyers and sellers for all real property insured transactions list out the documents of public record relating to sanitary and septic restrictions. It is up to the buyer of the property to review and educate themselves regarding this matter as the information is disclosed to them and individual documents can be provided to the buyer upon their request. I am not aware of any other county in the state of Montana that require this proposed document be filed with a deed of conveyance, and I do not think it is necessary. Please know that I oppose this resolution and am in hopes that it does not pass through the county commissioners. Thank you for your consideration.
Thank you, Ann. Julie, thanks for coming on down. Because you are on the agenda, would you like to go ahead and speak first to this resolution that was brought to the Board of Health and then brought forward today?
The resolution was originally, the original version of it was signed and passed by the county commissioners in 2011. So this is just a revision to it, and the only revision is that it's not applicable to properties located within the city limits of Townsend that have a service connection to a municipal sewer system. So the notification to purchasers was passed and signed, so it is a resolution that's binding to the county. It has not been adhered to. The commissioners asked me to revise it so it did not include properties that have a service connection to a municipal sewer system. But I have found that there are a lot of folks out there that do purchase properties and come to find out that it's not a usable lot in this state that it's sold to them. And as far as causing undue burden to either the clerk and recorder or the realtors or title companies, if this is a document that's just included in closing papers, they look at it, they see it, if they don't want to read it to see what it says, and they sign it, then that means that they're the ones that failed to do due diligence, okay? But at least they've been notified, you know, that there is a situation there. There's a copy of the subdivision plat so they can read on it that maybe the parcel is for agricultural purposes only, which means unless it goes through subdivision review and has sanitary restrictions lifted, it's of no use to those people. And just because, you know, the parcel exists, it may not be approved by DEQ. There may be an issue with groundwater, it may be an issue with steep slopes, there's all sorts of things that come into play there. The county, in the last couple of years, we have reviewed parcels greater than 20 acres that do not apply to the Sanitation and Subdivision Act. And so those, before they are approved as subdivision, we go out and take a look at them. We do test pits and we locate an approved location for a well and septic. And if that's not something the landowner, you know, if they don't want to put their house there and use that approved area, they have the right to come back and have another site evaluation done. But it's to protect both the buyer and the seller. Because if somebody's selling something and they don't have a clue what they're selling and that person buys it, you know, there's always a potential for them coming back to sue them saying, you sold me an unusable lot, or a lot that's approved for a different purpose than what I had in mind. So it's not as though it's going to stop a sale. It's just that it could be included right in closing papers. When somebody, you know, signs all the other closing, it could be there. And at least that information has been provided to both the buyer and seller. They know what this piece of property is approved for or not approved for. So as far as people coming in, I agree, people should do due diligence before they purchase a piece of property, but in most cases, they do not. And so when they come into me and I say, I can't issue you a septic permit, sanitary restrictions have not been lifted, or this is an agricultural parcel and you'll have to go through subdivision review with the planning board and the commissioners, and that's gonna cost you, you know, $1,000 to $1,500. You know, they're very unhappy with me and the county, but those are laws that are on the books. And so this is just to notify the purchasers of the requirements of the parcel before they purchase it, before they sign on the dotted line and sign all the closing papers. That's all it is, and it is provided for in the Montana Code. Just because no other county has implemented doesn't mean that if one does it, that they all won't follow suit. Sometimes it just takes that first county to make that step. So I'm just tired of being the bad guy that tells folks, well, this is locked, you can't use it. You know, you purchased it, nobody told you that. Sorry you didn't check it out, but there's nothing I can do about it. So that's where I'm at on that. Does anybody want to look at either the notification to purchasers or the proposed resolution? I'm sure it was read. That's all I have.
Thank you, Julie. Julie, I was just gonna ask you to stay, so thank you. I didn't read the resolution, and I think that's a good idea, so I'll just read it real quick. Be it resolved by the Board of County Commissioners of Broadwater County commencing with the passage and approval of the resolution prior to the submission of any deed for recording with the county clerk, Broadwater County Clerk and Recorder, and executed original revised Broadwater County notification of purchasers, section 76-4-113 MCA form shall be recorded with the Broadwater Clerk and Recorder. A sample copy of said form is attached to this resolution, and by this reference is made a part thereof. This form supersedes the prior form adopted by Resolution 2011-14 by order of the Broadwater County Commissioners. So with that, we have an awful lot of people here that I think will have comments to make. We didn't have this kind of interaction in 2014, and based on some of the stuff that we are hearing, it does not mean that we can't revisit this resolution as well. That decision couldn't be made today, but certainly I think it's only appropriate that we hear from the people who are experts in the field. And we did hear, I will say, a couple of years ago from a gentleman from a title company, I forget which one, and he was going to come forward with some ideas to solve this problem. What had happened is we had a rash of people who had gone to Julie's office. They had purchased property. They were unaware, through whatever means, that they had sanitary restrictions on that property, could not build homes, and had to go through a full subdivision review process, which is costly and time-consuming. What we were trying to do at the time was find some way to make sure that people knew what they were buying. And that was the reason for adopting this at the time. So I think the board is very interested in hearing what some of you experts in the field have to say, and any ideas you have that we could address this issue if this resolution isn't the best way to go. And it has not been actually a resolution that's been in practice because it has been opposed by the Clerk and Recorder's office. So any comments from our realtors or title companies or representatives of realtors? And please state your name for the record.
Good morning, Madam Chair. My name is Mark. My name is Mark Simnich. I'm the Executive Director of the Helena Association of Realtors. I have a letter here from legal counsel for the Montana Association of Realtors that I'll submit. I also have a letter from the Helena Association of Realtors that I'd like to submit. If I may briefly, the statute that is in place requires the notification between a seller and a purchaser. The statute does not require anything to be recorded with the clerk and recorder. That is not a requirement of the statute. The statute does say that if those two parties choose to record that communication between them with the clerk and recorder, that will serve as evidence, conclusive evidence, that they have complied with the statute of notification. The law does not require that notification to be recorded by the clerk and recorder, number one. Number two, the statute as it's written is very specific to transactions between purchasers and sellers of property within approved subdivisions. You heard from Ms. Ramey and from the title company people that there are a number of other type of property transfers, transactions that take place that don't fit within that kind of requirement. They may be deed transfers for a lot of different reasons. They're not within approved subdivision, or they're not between a buyer and a seller. The law should not apply to them, and yet the resolution as it's adopted says before any deed is recorded in the county, this form has to be filled out. So on those two bases alone, we believe that the county does not have legal authority to require those forms to be filed with the clerk and recorder, that notification to be filed with the clerk and recorder. We believe it's clearly outside the authority of the county to require. The comments from the title companies have described their issues and concerns with the process and how it potentially can slow down the transaction, slow down at the time of the closure, at the closing for the parties involved. And oftentimes those parties may be either out of county or even out of state. And so requiring an additional form to be filed, as the resolution says, before the deeds can be recorded. That means that has to be done as a piece of process before the closing is actually done. And it's just contrary to the way title companies work. Sorry, I don't know your last name. Julie, Sanitary made reference to this form could be used, and whether or not people read it or not is their own business. They need to sign it whether they know what is actually in there or not. The title companies, as a matter of practice, do include within the title report references to the certificate of survey, the conditions of approval on a subdivision, and those type of matters. That's exactly the kind of information that the title companies are looking at when they're preparing a title report. Again, they reference it, and it's up to those purchasers to determine how much of that information they want to then look at in depth and understand. The title companies, though, are playing that role to try and make sure that in those appropriate transactions, that information is included within the title report that is available. Bottom line is, though, we think that this is, other counties haven't done it because the law does not require counties to require recording of this information. We think it'd be appropriate for the county, for Broadwater County, not to adopt this resolution. Thank you.
Any other comments?
Chuck Harvey. I got caught in the middle of this last summer. And I guess my concern was if this was passed in 2011, it was never put out to the realtors. So we had no idea that this was to be done. And I got caught in the middle. Julie helped me through that last summer, but the same thing, and you know, it says on a buy-sell that a buyer is responsible to pursue the information and find out, but it didn't turn out that way, because when you get an attorney involved on the other side of it, they'll push themselves to force you to do whatever you need to do to make it work. But we hadn't been given, as realtors, we had not been given a copy of this change and didn't know that at the time. We still don't have the form, but we're making sure that that's one of the things we do in our practices, that we notify buyers that it either has or has not been lifted.
Thank you. Any other comments?
I do, I'm a realtor, but it was on a personal, sale that I did. In a Marcia Biber. Okay. And this involved, a piece of property that did not have the sanitary restrictions lifted. And it was a sale of. And in the buy-sell itself, it was put on the listing that was put out to all the other realtors and the buyer when they made an offer, that the sanitary restrictions were not lifted, and it was the buyer's responsibility. And that was 2 years ago, but those folks had already gone to Julie for her advice about buying the piece of property. And she said, no, it's okay, go ahead. And they have had substantial monetary output, you know, since then. So we gotta either do it or we don't need to do it.
All right, thank you very much. Any other public comment or ideas, thoughts? Okay. What we will do is, well, what do you think, Franklin? Do you have a thought on how you would like to proceed on this? I think with all the comments we have, we should postpone it. Do you have any other thoughts?
I agree with that. And we're gonna have to do some more research on it there, definitely. But at this point, I think we better table it, postpone it.
All right.
Can I make a suggestion then?
Yes, Judy.
If this is not going to go forward and be, changed that way, so then the next time you have a meeting on this, it should be either to, sign the new resolution or, throw out the one that was approved, so this doesn't drag on, because I need an ending to it too.
Right.
We've been dragging this out now for 2 years, and if we're not gonna do it, that's fine, I just need to know, so, yeah.
Yeah.
Okay.
We vetted this through our county attorney 2 years ago. Some of this information though is striking to me. And the fact that it didn't get sent out to the realtors specifically and title companies too by extension is concerning to me. It should have been, years ago.
Laura?
Yes,
I do
Julie?
have a list of title companies and people that I emailed the form and the
Okay.
notification to back in 2011. So,
Okay.
I mean, I'm happy to print that out, but, and Debbie can verify for me that those were sent out, and we never got one response from any of the well, we may have gotten one call, but, and it may not have went out to everybody. Our list may not be, totally inclusive, but that was to notify them that this resolution was going to be up and coming. And at that time, I think we only had Bob Davis, come to the meeting then. But I do have a list of title companies and stuff that I emailed it out to. And some actually, we didn't have emails for, so they were mailed out. And like I said, Debbie can verify that because she did the mailing for me, so.
Thank you, I'm glad to hear that.
Mhm.
All right. As far as at this point, I think what we need to do is put it back on the agenda, and address it as a full commission, and also, get the current county attorney's opinions of some of this, MCA language, also these letters that Mark brought us, thank you very much. So, we will table this at this time, and, we will keep you guys informed of how we proceed and move forward.
Thank you.
You bet, and feel free to call us at any time, and we'll be more than happy to share with you what's going on. And I think Julie's right, I think we need to, either amend the resolution so that it's more workable, or, get rid of the resolution, based on the fact that it may not apply to this particular MCA. So, okay, thank you very much. Any other questions on this matter? All right. It is 5 minutes till 11. We have Judy Tice, DOR, lease agreement at 11 o'clock. I don't see Judy here, so we'll do mail for just a few minutes if that works. For everyone. Yes.
These items are legal also this morning.
Yes. Yep, we'll just plow right on through and just get everything done to take the lunch break today. You bet. There you go. Oh, my notes are there too. I don't know if you want those. All right. I did print off the mail for you, Franklin, and put copies in your mailbox. I noticed it's still full after, as of this morning.
I didn't get to it. They didn't get it.
All right, so we have, first off, payroll. Oh, excuse me, I'm gonna start with minutes, just so we can take care of last week first and then move on to our new week. So we have July 15 and July 22. And these both were emailed to you earlier this week. And hard copies are also in your mail in the office. Hi Judy.
Am I up?
You know what, in 4 minutes,
Okay.
yes.
July 15th, sir.
Okay, is that a motion?
Yes.
Okay, I will second the motion. It's been moved and seconded to approve the minutes of July 15, 2013. All those in favor signify by saying aye. Aye, motion carries.
9th.
How about July 22nd?
Oh, okay, 27th.
All right, I'll second that.
Yes,
It's
29th.
it's been moved and seconded to approve the minutes of July 22nd, 2013. All those in favor signify by saying aye.
Aye.
Aye, motion carries. All right, it is 1 minute till 11. Judy Tice, Department of Revenue, come on up. We will be talking about the lease agreement. The county leases space to Department of Revenue, which is a state agency, and the reason we do that by and large is customer service to people, because people who come in to visit with, actually I'll keep that for later. With Department of Revenue oftentimes have business to take care of with the clerk and recorder, with the county sanitarian, and it's all just right there across the hall. And we received a memo, thank you very much, Judy. That rent would be going up or going down, the amount being paid would go down to the counties.
Right.
So, the floor is yours, I guess.
Well, I guess I'm just here to answer any questions that you would have. I provided that the Montana Code 158102, counties to furnish office space allowable charges, and that's determined by the Department of Administration. And so that's something that is decided during legislation. So nothing that any of us really, unless we went to legislation to sit and argue for or against their decisions, we can't decide or make a change of now. It's something that was set into law at that time. And so they have just said it, that the base rate will be $8.43 per square foot for 14, and then $8.12 or 21 cents for 15. So those are the reasons why the what we would be paying would go down based on the determination of Department of Administration. So, and it's set that if there's a space available for us in your county building, and if there's not, then we just need to, and if it's something that you're willing to agree on the terms of the lease, then we can renew our lease, and then if you can't agree on the terms of the lease, then we would terminate our lease and move from the courthouse. Any questions?
Thank you very much. Judy and I spoke on the phone, and this was not Department of Revenue's doing, it was not Judy's doing, certainly was not Tracy or Jen's doing. This was part of House Bill 2, and we may not like it, but it is what it is. It looks like the rent will go from fiscal year 13 this year of $71.57 to $71.35 next year, a decrease of about $22, and then to $69.51 in fiscal year 15, a decrease of about $80. So we do have a couple of choices, Franklin. We can sign this agreement and solidify these amounts for the next 2 years, or we can decide to terminate the lease and ask DOR to move. I will reiterate, even though the money is a decrease, the reason that DOR is in county buildings and has been here is a customer service to our citizens. And, you know, thinking about our more elderly citizens who come in here with canes and such, send them downtown, we need to service them as well. That's just my commentary. Any thoughts, Frank?
What factors they use for the decrease?
Did you happen to call Garrett Bacon and discuss that with him?
I
I
did.
honestly don't know why they came up with the decrease. That would be something that you would have to discuss with the Department of Administration. Did he explain it?
We played phone tag for 2 days and then he was on vacation for a day. So, yeah, no, I didn't get any solid information from him. The bottom line is there was an awful lot done in House Bill 2 to try and grow the rainy day fund at the state level and to cut back on expenses. And this just looks like another example from the state, you know, sending decreases in funding to the county level. To me, it's not something we have any say over. It's certainly not something Department of Revenue has any say over. It is what it is.
And when the House bills are introduced, you know, anybody can go sit in on those hearings and give their, input. And it's probably would behoove small counties to kind of see where they're at, you know, on those agendas, just to make sure that if these cutbacks are coming down the line, that you guys don't feel the impact of them.
And I think it's something we want to address with our representative and whoever our new
Well, that
senator.
that's 22 a month, and the other's 80 a month. These are just,
Do you have your paperwork with you?
no.
You can look online. That's the total right there at the bottom of the graph. It's not a significant hit to the county. Oh, thank you. Let me give you that as well.
I'm sure, may I make a comment on this?
Please, yes.
No one in the county likes to get less money. But in real cost, it would cost both the county and the state employees more money if they were out of this building, because the clerk and recorder, county treasurer, sanitarian, and the Department of Revenue all work together very closely on a daily basis. And if it gets down the street, it's going to take more time to get everything done.
Thank you very much. Which is a hit to customer service again.
Well, yeah, I see where it's handy here. I still think we could leave it as it is. Make them an offer back and see what they say.
That isn't the way it works, Franklin. The House Bill 2 is the funding bill, and that is, goes through the legislature. It's usually the last bill every session that goes through, and it sets things like rent that state agencies will pay county agencies. This is something that is decided in House Bill 2, and there is not an avenue for a county to challenge. Essentially,
Any
House Bill
reason
2.
why they're dropping
Well, it was something decided by the legislature. Again, what the legislature doesn't always make common sense to us at this level.
them? I know that. We don't have to make that decision today anyway.
No, but we should make it pretty soon so Department of Revenue knows where they stand. Do you wanna table this too?
Yeah.
Okay, thank you though, Judy, for coming and talking to us about this.
I can give you any other information, just let me know.
Okay, sounds
Let us
good.
know. Thanks.
All right, thank you very much.
Have a good day.
All right, let the record show we will table the, rent. I will make this comment, it's about $500, almost $600 regardless that they'll be spending for 2 offices upstairs. It's actually pretty good rent, for the offices. So, next appointment is at 11:15. How about we do some more mail?
I got this report from the minutes, when I read those, it reminded me about this DES, and I'll give that now.
All right.
I talked with both Brenda and Mike Conkey. I just made a few notes here so I can remember as I'm going along. And Brenda says, as far as neither her or Mike have been put on as deputy DES coordinators. I guess there's some talk that Flannery never did do anything. And with this interagency agreements we have, say a fire, for example, her and the fire chief take care of it, or Mike Conkey. As far as the DS, Flannery being here, he'd never show up until after the fact, is what the report I got from both Mike and Brenda. And so anyway, between Mike and Ed and Brenda, they handle, and the sheriff, of course, has she's the very first one notified of any type of disaster. Let's see, what was the other thing here? And as far as Mike, when I talked to him, he was still out on Superior Fire. But if he is contacted right away, he could leave any of those. The people he works with are also qualified DES people. But he could leave a fire and come back. And another thing, I guess it didn't really affect the county so much, but I talked to the state people on the Tossin Dam, and they have a lot of exercises on that, the Tossin Dam and the hydro plant there and everything. And anytime they've had them, the DS coordinator, Flander, has never ever showed up on any of them.
All right. Mike Conkey may appear today during public comment to bring us up to speed on DES issues. Mike and Brenda have been referred to as his deputy DES coordinators, but an official deputy or DES coordinator has to be sworn in.
That's right.
Correct. So that is something that we should address before there's an emergency. And I think we should hear straight from the experts on that, who would probably be Mike. He's able to make it today. As far as
no matter what, the sheriff is the expert, because the first knowledge of any disaster of any kind, it's the sheriff's office.
And I think that's where a little bit of education needs to come in. It's not somebody working the emergency that we're looking for. What we're looking for is a liaison to keep us informed, so that when they need something from us, that we're able to get that to them as quickly as possible. You're right, the sheriff would be working the emergency. The fire chief would be working the fire.
Just like they always have.
Correct, there's no question. What we're talking about is another position, a separate position from those two. We're not looking for the person to work the emergency, we're looking for a liaison. And that's what the DES coordinator's job has been. As far as notifications as to what's been going on, in the past, we have received daily emails, just to give us an update of what's going on, so that we're not blindsided or surprised by anything. Should an emergency action be required, then we have the backup information to know what's going on, so we can make a very quick decision.
Yeah.
So, thank you for doing that. And anything else on that subject? Franklin?
No, other than I feel that everything is under control.
All right, we started with payroll. We have payroll for pay date ending 7/23/2013 in the amount of $137,531.52.
Yeah, I'll make a motion to pay the payroll. Here you go, 7/23/13. Yeah, and the amount is $137,531.52.
I'll second that. It's been moved and seconded to pay payroll of $137,531.52. All those in favor signify by saying aye. Aye, motion carries. We have a couple of claims. This one is in the fiscal year 13, but because I signed it, I will ask you to initial it. This is a claim to Poor Roth and Robinson out of Butte. This is the attorney that helped us through the contract bargaining this year, and the reason she was contacted was to get some more information on the Public Safety Commission for our law enforcement. And that is required in order to have an interlocal agreement.
$74.
Mm-hmm. Thank you. Next, we have a claim. This is from WWC Engineering, and this is for floodplain work. And they are our floodplain administrator.
Is this addition, I thought they were through with this. Is this something that's come on later, or what?
there's never a through with this. Anytime anybody buys some land that may have floodplain on it, they will have to go through a legally set process in order to get the floodplain restrictions lifted, and they go through our floodplain administrator. Our insurance company has said that it is wise for any county to have a separate floodplain administrator because it's an additional layer for liability. And that was Greg Jackson, who was here visiting with us a couple months ago. This is ongoing.
Yeah, just do the initial.
Yes, and I will go ahead and sign. All right, it is 11:15, and we have a COS review. Deb, is that why you're here?
Yes, ma'am.
All right.
I apologize for the newer copies. There's a couple for you to look at. This is a parcel of land owned by, the Carps out across from the dump site, on the way to Helena.
Oh, okay.
I can't think of the name of that road right there, but it's just. Right there, they own this piece of ground and they are dividing, it for their son and the wife. There's two family transfers. The son is gonna build out there, they wanna keep one, and, well, they're keeping all of them for family.
Okay.
And it's been through the sanitarian and the examining surveyor.
Okay.
And while you're looking at it, I could grab the sign
Okay.
sheet.
Thank you.
This must be north of the road they have now, currently. Is that the line?
And if you have any questions.
Do we need a motion to go ahead and?
We don't approve these, but we do support or acknowledge them, so yes, we do need a vote. A motion.
Motion to continue with this family transfer.
The Carps.
I will second that. I will reiterate the motion that the commission it's been moved and seconded to support family transfer for the Carps. Is that agreeable to you?
Yes.
All those in favor?
Carps, not Clarks. Carps, right?
Carps.
Correct. Yep, all those in favor signify by saying aye.
Aye.
Aye, motion carries. Thank you.
All right.
Thank you very
Thank
much.
you.
Any other COSs? All right. We will have Sean Higley here in about 12 minutes. So we will continue with some mail, if that is okay with you, Franklin. Okay, we have approved claims from last week, and this is for fiscal year 14. In the amount of $25,523.14.
Oh, yeah. I'll make a motion to accept the claim for voucher number 1003 for the amount of $25,523.14.
I'll second the motion. It's been moved and seconded to pay the approved claims of $25,523.14. All those in favor signify by saying aye.
Aye.
Aye, motion carries. these are the approved claims from last week for, for fiscal year 13 in the amount of $21,605.58.
I'll make a motion. Those claims are voucher number 1123, $21,605.58.
I'll second the motion. It's been moved and seconded to pay the approved claims for fiscal year 12 in the amount of $21,605.58. All those in favor signify by saying aye. Aye, motion carries. We have a couple of grants that will be coming. We can't sign these right now because they just came in. But they are with the trust board, and they have a proposed grant with the Booster Club to help with lighting at the football field. And we'll address those. Actually, I'll keep this in. We'll address those next week.
We're not gonna act on this now, right? Never said.
Right, it requires a signature, and we have not noticed it on the agenda. So that will be on next week. And if you want me to print a full copy of that for you to peruse this week, prior to next week, I would be more than happy to do that. Okay, then
Sounds
I'm,
like a good,
yes,
project.
Mr. Bray.
Oh, Bray, a point of interest, how much is the grant for?
Is it 44,000 there? Or is it,
Yep,
I think
the
so.
trust board has committed 44,000 for the
Yeah.
improvements.
the requested grant
and
amount is
upgrades.
44?
They were able to take out, they're sitting at quite a hefty amount. They were able to take out, I think it was 200 grand last year for these kinds of grants. So, they have another one here too with the golf course, funding for, projects and improvement of 18,622. So they're gonna be doing some big projects. The board, approves them, and then it comes to the commission for final approval. And if you wanna see the grants, anyone is more than welcome to. Okay, and I'm gonna go ahead and continue on since, these are up next week. This is from, Montana Fish and Wildlife Commission, and they will be addressing new rules for salvage permits, and this is for animals hit on the side of the road. And again, there's a copy in your mail basket for that. We also have a notice of temporary shooting restrictions in the Copper City area. This was imposed by BLM after the fire of last week. There's a map there, and they will advise us when they have lifted those restrictions. They were fighting fire and had some people come in to do some more shooting, and it was a ricocheting bullet that caused the fire, so that's what caused that action. This is a water result analysis on the well testing at the silos. This is in response to the letter received last week from DEQ regarding those testings. This is just a T-crossing and I-dotting. We already signed that contract, and that is just the original that came back to be filed. And this is from Montana Department of Environmental Quality, DEQ. to the Richland County Commissioners, and it is regarding wastewater discharge permits for Salvage Lagoon.
Which one is this in here?
That is for, that's with MDT.
Is that deep, or is that the one out here?
I do not remember, that's, came in late last week, so whatever it says, and we'll just be filing that, and we have already done the signatures, and they have the originals.
Yeah, I was just wondering which one it was, though.
And you do have a copy of that as well in your mailbox.
Yeah, but I still don't see, I guess it doesn't make any difference, because we were just wondering which one it was, though.
And this is from Montana Fish and Wildlife and Parks. And this is, they are taking comments through the 5th of August, 5 p.m. We'll put this on the agenda under items for discussion for next week if anyone has any comments. This is on the 2013 early season migratory bird regulations. And again, this is public comment. So if you have any comments, just let us know, or you can submit them yourself. And if you want the information, there's a website we'd be more than happy to share with you. And this is the loan activity history from the Shogia LLC, and this is the turning lanes down at the south end of the county. The developer's name was Greg Show, and this shows a record of his payments on that loan, payments in full for May, June, and July. And it's 11:25. Since we're running a little bit early, we can go ahead and start our next appointment. Our schedule does say items are subject to change, so Sean Higley with WWC is next to talk about Deep Creek Project grant support.
Okay.
And if you would like to sit down, you can move a chair forward or sit there on
Sure.
the side, whatever works for you,
I can
Sean.
go over here.
That'll work.
All right. Handout for you. Sorry, let me throw that a little bit.
Thanks.
Not helpful things, getting information. Okay, I guess in light of recent events, I'd like to kind of just update the commission on where we're at with the Deep Creek Hazard Mitigation Grant. So just a little history. Obviously in 2010, 11, and 12, we had pretty significant flooding out on Deep Creek. In 2011, there was a presidential declaration, and what that means is there was more federal money available to help take care of flooding hazards and mitigation from that year. So through the Bill Fleiner and work with the sheriff's office, we were able to get enough information together to submit a grant under that timeline. So we were able to get a grant in under the 2011 Hazard Mitigation Grant Program, which I think is somewhere around altogether about $1.7 million. So I guess what I'm doing today is just kind of give you, this is basically the scope, kind of where we are. I think a lot of the problems that came about, started a lot of the flooding were, well, of course, the fires that occurred up in the forest. I can't remember the name of the actual fire that was up there, but what it did is resulted in a lot of sediment coming down into the drainage and basically filled in a lot of channel areas, which, of course, when you start filling in the channel, your floodwaters come up because they have nowhere else to go. And so with this grant, what we're looking at is a two-stage approach. Number one, we gotta really figure out what's causing the flooding and where those problems are happening. Once we do that, then we can actually put mitigation actions into place to correct some of these situations and make it safer for everybody that's out there. And really, I mean, a lot of the people that are living out there hadn't seen flooding in the whole time they've been out there, except for recent events. So that's kind of what prompted us to take a look at this thing. Basically, we've went through 3 rounds with FEMA now to get the grant. I guess all the information that they need for the grant. I've just completed the last round of information that they needed, got that into them. I think, we're hoping anyway, that that'll take care of everything they need. They're being very picky, but Montana DES, who's running that program, told us that they would be. And I was actually possibly going to be asking for a letter from the county today, but it appears that we do not need that now. It looks like Montana DES has accepted our information, and hopefully we will have some grant funds available late this year or early next to start that process. So that's kind of a very generic overview. If you have any questions, I'd be happy to answer any of those, but
Sean, who are some of the partners who have been working on this?
sure, we've kind of through the process, and Bill Fleiner was kind of in charge of this stuff, but we've been working with the local conservation group, with Montana Department of Transportation, Fish, Wildlife and Parks, the Forest Service, NRCS. So we've had all these people as part of this project, and the way personally I'd like to see it go is all those project partners stay involved throughout the process, including a landowners group that's been formed out there on the creek. And really, I think through the landowners group is they'll kind of direct where things really need to go. And, you know, obviously we'll have to get a consultant involved to help with this thing, but they'll be kind of driving, I think, from, you know, here's the scope of work, and getting input from all the agencies that are involved, because they're gonna be instrumental. We can't go forward without knowing what MDT's doing, both on their system upstream and in the canyon. We can't go forward without knowing what NRCS is doing through their EQIP program with bank stabilization projects and things like that. And same thing with the Conservation District, Forest Service. Those things are all gonna be critical in making sure that everybody is kind of bought into this whole watershed program. So I think that's where we're at. And hopefully we'll continue that way. And everybody seems to be working together pretty well at this point on that. And I don't really foresee any necessary problems going forward to get this thing done. So hopefully the main goal, obviously, is the people that are out there living along Deep Creek, maybe we can give them a little relief when the next flood season comes. So.
Any questions from the board?
No, I've heard a lot from the Conservation District.
Yeah. There's a lot of information here, but if you guys have any specific questions, if anybody has questions about it, I'd be happy to answer any questions.
All right, any questions from those of you who are here?
Is Bill Fleiner still?
Please state your name for the
keeping him
record.
on?
State your name for the record if you would,
Dwayne
please.
Hall.
Thank you.
That's Commission Betterfield. That's a
I
question.
mean, you brought him into it, you said.
Yeah, I've been working with him on this
Yeah.
grant program. I understand he's now on administrative leave, so I'm taking over kind of the lead at this point on this project.
Okay, then you'll be in it over this deal and?
Yeah,
Okay, that's what all I need to know.
sure.
John?
My name's John Wright. What is the difference in the cost that you apply your cost versus Bill's cost per hour on doing this chore?
So, actually, to date, I haven't charged the county anything for this. I act as the floodplain administrator for the county as well. But, this is an important enough project that I've kind of taken this on. I probably won't do that forever, but at least to get this thing going and off the ground, I think it's that important. So, I got a lot of calls, when people were getting flooded out, so.
Let me revise my question. We know approximately what Bill was charging per hour to do his things.
Yeah.
If you did apply it, how much would you apply per hour?
You know, it
What
really,
rate?
our billing rates are anywhere from $50 to $115 an hour, just depends on the
Okay, so
person
it
working on it.
would cost more money.
Yeah, obviously.
Okay, all right.
Any other questions? Sean, we got an email last week from Ron Spoon and Denise
Mhm.
Thompson. How does their grant connect with this grant? Is it a separate issue, or is it another partnership that's kind of coming into play?
I think I haven't had a chance to talk to Denise about that. They requested information, which I was happy to get them, got it to them Friday morning. Hopefully, they had enough time to get everything put together. But I would assume it's still along the same lines of the same goal and continuing that partnership towards, mitigation of the flooding hazard out there. But I will discuss that with them, of course.
Okay.
Yeah.
And you say you don't need the support?
No, basically, all that was taken care of in the original application. I got to looking back through everything, and I'm like, they're requesting information that we had already provided.
Okay,
So.
all right. So the update is still very good
Yeah,
for us.
everything, I talked to the Montana DES coordinator, Nadine Wadsworth, this morning. She indicated that she had everything, they reviewed the information that we submitted, they thought it was more than adequate. We'll submit it to FEMA and find out what happens.
All right. Okay. Still no more questions? All right.
Okay.
Well, thank you. Any idea as far as timeline?
Well, we're hoping, that later this fall, they'll
Okay.
approve the grant. I'm sure they'll have some sort of a contract and things like that they'll, you're gonna use the money specifically for this type of thing and, standard governmental, grant funding contract so that'll take, I would assume, a month to 2 months to get through the process. Those kind of things just take time. And so hopefully if we can get funding, we should be able to get somebody on board and going with this thing yet this winter, maybe, early next year. And maybe try to start to get some hazard mitigation stuff going with construction in 2014. That's the goal. It depends on FEMA and how fast they get through their process.
Okay. When it gets to that point, we'll look back and think it was a very short amount of time. It doesn't feel that way right now, especially for
Yeah.
you, I'm sure.
Yeah, well, as long as we don't have a lot of snowpack, the phones don't ring as much, but when we start getting piled up on the snow, that's when we have to worry about it.
Yeah. Thank you though for picking up that ball.
Mhm.
Really appreciate it.
Absolutely. Okay, I've got extras here if you need them.
All right. I will take an extra for Elaine.
Okay, yeah, I think I got an extra.
Yeah,
there.
you already did.
One
Perfect.
extra here.
All right. Thank you
You bet.
very much.
All right, thanks.
Have a good day.
You too.
All right. We're moving right along today. And do you have anything more to add, Franklin, for the good of the order?
Are you talking with Brenda and Mike, you mean, or what? Otherwise, I don't have anything right now.
Okay. a letter from the airport, and I will get you a copy, this came in this morning. And Bob Hollister would like to either meet with the commission to discuss their budget. They have some leftover money they put into a CIP. And what they have coming up is a requirement by FAA that they re-blacktop the runway for the airport. And those grants are now a 90-10 match. They used to be 95-5. So they'll be needing to put away some money into a savings to cover that. I believe that's required here in the next year or two. Do you have a preference on having a commissioner go and meet with them during their meeting time, or would you like them to come and meet with us during our meeting time?
Let them come meet with us.
Okay, I will share that with Bob. Can I keep this and get you a copy? Okay. Okay, and you are a representative for that board. Have you been in contact with them about this issue? Or should I ask them to bring forward a full update for us?
Yeah, I haven't been in contact with them. The airport?
Okay. Okay, I'll ask them to do that then. And I think we are up to public comment. Any public comment today? Joan, and please state your name for the record.
Joan Hill. I was wondering when they was asking about this topping for the roads, how much difference would it cost over the years to have the topping put on roads compared to maintaining?
Are you talking about chip sealing, or are you talking about road stabilization?
The stabilization.
As far as an actual definitive price on a particular road, we don't have that, certainly not just point blank.
Yeah.
Dana is the road supervisor, and he could talk to the savings in man hours, in wear and tear on vehicles, on equipment, in time savings, gas, diesel, which we all know is a premium. So he could have probably addressed that and get you some solid numbers.
Well, I imagine it'd take quite a little work to find it all out, but it might be something to find out. And then also on the shouldering on Jack Farm Road.
Shouldering,
They put that oil off Jack Farm Road, and if you'd have to drive off the road, you'd be about that much of a drop, a sharp
Okay.
drop.
okay, I will, let Dana know.
Okay, thank you.
All right, thank you very much, Joan.
I think he was going to address that one and the one on Old Town Road. I don't know whether he apparently hasn't yet.
I'll check with him and find out for sure. Mr. Brady,
Laura, can I offer a comment about the stabilization of the road?
you bet.
In our subdivision, Sunrise Estates, right above the golf course, we just had the magnesium chloride put on a mile of that road. It cost about $4,400 total. So I don't know how that compares with the maintenance of the road, but the reason we had it done was for dust abatement. And like I say, I don't know how much that compares with just maintenance of a gravel road, but that's the approximate costs.
Yeah, it's a big chunk to start, but boy, getting rid of that dust is huge. And it does help with the washboards developing too. Yeah,
Besides that, people are afraid to get mag chloride on their cars, so they drive more slowly.
an added bonus.
It is a bonus.
Yeah. Hugh,
Laura, you had on the agenda Tim Ravendall, and he's not gonna be here. But you also have on the agenda comment or discussion of his proposal.
correct.
I don't know if this would be a time that, since he's not here, to respond to it or not. I do have a statement I'd like to make on that.
Okay,
But it might not be appropriate if he's gonna be delayed or not, I don't know.
it's been
You've been,
postponed
you-
and canceled for months, literally. at this point, so it's up to you if you'd like to wait
I
until.
think I'd like to make a statement now, and
Okay.
might repeat it, because I don't know if I can come next time he's here. So
Sure,
can I do that? It'll probably take 5 minutes.
absolutely you can, yes.
All right.
And state your name for the record if you would.
All right. My name is Hugh Van Swearingen, and here are copies of my statement for each of the commissioners, and for Elaine, and that one here. As you know, Tim Ravendall has been talking about some resolution to bolster the Second Amendment. This business is just plain silly. It has nothing whatsoever to do with running Broadwater County. It's a waste of your time and a waste of my time. What we have here, as I've read them, are 3 or perhaps 4 versions of a resolution, all proposed by Tim Ravendall. In its simplest form, it would have Broadwater County's Board of Commissioners affirm support for both the Second Amendment to the United States Constitution and Section 12, Article 2 of the Montana Constitution. Both of those give us the right to bear arms. Why single out the Second Amendment for support? The United States Constitution has 27 amendments. Are we to pay homage to the Second Amendment above all else, above all the other 26 amendments? Or perhaps we should single out the first 10 amendments as deserving an affirmation of support from our county commissioners. The first 10 are often referred to as the Bill of Rights. Indeed, we cherish all of them, all 10. They include freedom of religion, freedom of speech and the press, freedom to assemble, freedom from unreasonable searches and seizures, rights to speedy trial, trial by jury, protection against being held in double jeopardy, protection against being held under excessive bail. Is one more important than the other? Is the Second Amendment paramount? Of course not. So if you're going to declare or affirm support for the Second Amendment, let's have you declare support for the entire Constitution, or at the very least, and one by one, for the 10 amendments that make up the Bill of Rights. Similarly, why single out for support the right to bear arms section of the Montana Constitution? That's just one of 35 rights spelled out in the Declaration of Rights that make up Article 2. In addition to the right to bear arms, they include freedom of religion, of speech, the press, freedom to assemble, the right to due process of law by jury and trial by jury, civilian control of the military, and they guarantee that all political power is vested in the people. Is one more important than the other? Not to my way of thinking. So once again, if you intend to declare support for the right to bear arms, you should as well affirm your support for the entire Montana Constitution, or at the very least for all 35 sections of the Declaration of Rights. After all, you commissioners took a solemn oath, each of you, to support, defend, and protect the Constitution of the United States and the state of Montana, so help you God. I take you at your word, not just the right to bear arms, the entire Constitution of the United States and the entire Constitution of the state of Montana. In another version of this nonsense, Mr. Ravendall would have you declare that any federal law or rule, executive order, etc., that goes into effect after last January 1st is invalid in Broadwater County if it infringes on the right to bear arms provision of either the federal or state constitutions. This is pure rubbish. The Supremacy Clause of the United States Constitution, Article 6, Paragraph 2, declares that the Constitution and the laws of the United States shall be the supreme law of the land. Time and again, the Supremacy Clause has been cited by the Supreme Court to invalidate state laws that contravene or attempt to override the federal Constitution or federal law. Does anybody here honestly think a Broadwater County resolution, contrary to federal law, would stand up in court for even 1 minute? Of course not. This is silliness. Just in recent months, a lot of marijuana growers and suppliers in Montana went to federal prison for relying on a Montana law that legalized medical marijuana. Again, will a Broadwater County resolution contravening federal law stand up in court? Fat chance. And remember those goofy freemen of 20 or so years ago in Garfield County who established their own laws for what they called Justice County. The FBI took quick care of them. They ended up behind federal bars. I believe at least one of them died there. Mr. Ravindall is fond of handing out copies of the United States Constitution to newly elected public officials. I suggest he read it himself. You simply cannot rely on state or local law to thumb your nose at federal law. Further, to make matters even more absurd, his proposals ask you to support our county sheriff in preventing the enforcement of federal laws, rules, regulations that infringe on the Second Amendment or Article 2, Section 12 of the Montana Constitution. What in the world is our sheriff being asked or told to obstruct the FBI or other federal agents? This resolution would put our sheriff in an untenable position. I can just imagine Sheriff Brendan Ludwig being indicted for obstructing justice in defense of a misguided resolution adopted by our august Broadwater County Commissioners. Never pick a fight that you can't win. If Mr. Ravindall wants to take on the government, let him pick a different venue. This is not our county government's fight. This is unmitigated nonsense that has nothing whatever to do with the governance of Broadwater County. Thank you for your time and attention, and I urge you to reject all versions of this resolution. Thank you.
I have a question.
Thank you, Hugh. Yes, John.
My name is John Wright.
Uh-huh.
Very inappropriate time that you've made your suggestion, when Tim is here too much of the time. First of all, a lot of your promotions and your accusations are crossing over between constitutional law and its 10th Amendments and the state statutory law and the federal statutory law, which don't ever get together. They're two separate laws.
Thank you for your comments.
I'm not done.
Well, I'll listen.
I sit and listen to you.
Okay, I'll listen to you. That's fine.
Okay, please do. Consequently, our Second Amendment under the Constitution of the United States is one major purpose: to protect all of the 10 amendments, not the rest, if you really study it. Okay, the Second Amendment is under siege right now in our nation by the federal government, which has no authority to alter or change it unless they do a constitutional convention. There has not been a constitutional convention since the 10th Amendment. 10th Amendment, which was done in the United States Court of Appeals, Washington, D.C., District of Columbia Circuit, which has been there since the late 1780s. Not the federal government, which really dug in after the War of 1812. All right, you've got two different sets of laws. We're under attack. The commissioners should, according to your oath, uphold the Constitution of the United States first and foremost, over all of the laws, domestic and foreign. Tim Ravindall has made this a simple proposition that you and our sheriff and all elected officials in this county uphold the Constitution as it's written, as it's performed, as its due process of law. And to interfere it on a federal level like he proposed, or allowing it because it doesn't mean nothing, well, it means everything. Your oath mandates it. I recommend you to discount what he says and what he's promoted and move on with the Constitution of the United States, upholding your oath of office to the letter of the law as per due process of the law.
Okay, thank you, John.
Boy,
Any
am I
other-
glad to hear that wonderful, knowledgeable constitutional dissertation.
What's your name?
My name is Paul Gray.
All right, that's what I had to give them mine, so you put yours up there.
That's fine. I've done it before. I'll do it again.
All right, any other public comment? Any other public comment?
Yes, I do have one more.
Any other, comments from the board? Okay, John, one more?
My name is John Wright. As I was coming into the courthouse to come to this meeting, I observed a very serious violation of safety rules and regulations as well as common sense. The roofing contractor is throwing material off of the roof into an open container. to mandate it as per simple as well as regulations of roofing. It needs a slide or a slip chute from the roof. That eliminates the splattering of nails and debris, and if the wind caught it, it could cause severe damage. This is a common practice, and it's under law.
Thank you, John.
And I wish you commissioners would look into this immediately.
Thank you. Any other public comment? All right, that's 3 times asked. Today's meeting is adjourned at 6 minutes to noon. Thank you for coming and have a good day.
Is there an afternoon?